Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. The time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. In this episode, we will be talking to you about legal professional privilege. We will start with a brief explanation of what it is and then cover how it could be relevant for pension schemes. I'm very pleased to say that I'm joined today by two of my colleagues in our pensions litigation team, Stuart Pickford, the partner who heads up our pensions litigation team.
Hi, Beth.
And Tom Wild, a senior associate in the team.
Hi, Beth. Thanks for inviting us here today.
So, as mentioned at the start, we are going to talk to you today about legal professional privilege. This is essentially the right to refuse to disclose confidential legal advice, whether in litigation or in response to a request from a regulator. Stuart is going to start by briefly explaining what legal professional privilege is in a bit more detail.
Thanks, Beth. For anyone who's already familiar with these concepts, today we're just going to be talking about legal advice privilege. There are other sorts of privilege which might be relevant to pension scheme trustees, but legal advice privilege is the one which is likely to affect most trustees from day to day. For the sake of brevity, we're just going to refer to privilege from now on. The idea behind privilege is that anyone should be able to obtain legal advice in confidence, without having to worry about whether their communications with their lawyer will have to be disclosed later. As with everything, there are some exceptions, but that's the basic idea. Before looking at privilege in the pensions context, we're going to look at three key ingredients of privilege.
Thanks, Stuart. The first key ingredient is clear. Legal advice privilege only applies to communications between a client and their lawyer, not between a client and a third party. This means that privilege will not protect communications between a client and another advisor, such as an actuary or a covenant advisor. Also, privilege doesn't just protect the communications themselves. It also protects any record of privileged communication, such as a note of a call, or an advice note given by a lawyer, or any other document which records the substance of the legal advice. Many documents will serve more than one purpose. So, for example, a set of minutes may record advice given by the trustee's lawyer at one point in a meeting, which would be privileged, as well as recording other matters which are not privileged. Tom, over to you to cover the second key ingredient.
Thanks, Beth. The second key ingredient is the purpose of the communication with the lawyer. In order to be privileged, the communication has to be for the dominant purpose of giving or receiving legal advice. That means that not all communications with lawyers will necessarily be privileged. But law does take a broad view on when a communication will be for the purpose of giving or receiving legal advice. When someone instructs a lawyer, they're often not just asking the lawyer to tell them the law, but what they really want is advice on how to deal with a legal issue. So where advice is given in a legal context, it will be privileged. On the other hand, if a lawyer gives advice on purely business issues or suggests somewhere for dinner, that advice won't be privileged. Where the advice is given by a law firm rather than an in-house lawyer, there is unlikely in practice to be any real issue about whether the dominant purpose test is satisfied. There is, however, more need for caution with in-house lawyers, because they often exercise more than one function. So, for example, they may have a legal role and an executive role. So it's necessary to think about which hat they're wearing.
The third key ingredient is confidentiality. Privilege can only attach to a confidential communication. If it is no longer confidential, it cannot be protected by privilege. But often trustees and employers will want to share with each other the advice that they have each received. Would that mean that the legal advice is no longer confidential and therefore no longer protected by privilege? Well, confidentiality is a question of degree. If I obtain legal advice, I can share it in confidence with Beth and with Tom, and it will remain confidential and privileged as far as the rest of the world is concerned. But if Tom then shares it with a number of other people, it's going to be difficult to say that it remains confidential. So any privilege may well have been lost. So what this means in practice is that trustees can share the legal advice they have received with the employer or with the scheme's other advisors, but they need to take care to ensure that it remains confidential. And it's prudent to agree some ground rules before the advice is shared.
Exactly. So let's take as an example the trustee sharing privileged legal advice it has received with the employer. At first, the employer should agree to treat it as confidential, and it's advisable to specify what they can and cannot do with it. Secondly, it's also a good idea to agree with the employer what advice is going to be provided and what is not going to be provided. Ideally, the trustee will want the employer to agree that they will take whatever steps might be necessary to protect the trustee's privilege. For example, by informing the trustees promptly if anyone tried to obtain a privileged document from the employer. When materials shared with the employer in this way, it's called a limited waiver, because the trustee will have waived the right to rely on privilege against the employer, but not against the rest of the world. So trustees can choose to share a document whilst maintaining privilege, but they can also choose not to rely on privilege at all.
That's right, Tom. Privilege is the right to withhold a document. It's for the party with that right to decide whether to exercise it. There may be occasions where trustees will want to disclose the legal advice they've taken. A good example of this would be a blessing application, where trustees take a particularly important decision for the scheme and want the court's seal of approval that they've exercised their decision-making role in a proper way. The trustees will need to set out the basis on which the decision was reached. This would often involve putting before the court any legal advice that they took into account. But there are obviously other circumstances in which privilege will be important. For example, if the trustees are involved in a dispute and they ask their lawyers for an opinion on the strength of their case and the best way to deal with it, they would want to be able to obtain that advice without the risk of it having to be provided to the other side's legal team. So anyone entitled to rely on privilege can decide whether to assert that right or to waive it. But the right to rely on privilege can also be lost inadvertently, without any positive decision to waive privilege. This usually happens if the advice loses its confidentiality. It's therefore important to make sure that you keep legal advice confidential if there's any chance you will want to rely on privilege in future.
Now we have set the scene by explaining what privilege is, we're going to move on to how it is relevant to pension scheme trustees, as trustees can rely on privilege in the same way as anybody else. In a pensions context, we are seeing more and more requests from the regulator for access to documents, and the requests are often wide enough to cover legal advice, so privilege becomes relevant. Although the regulator has broad powers under the 2004 Pensions Act to require information and documents to be produced, the Act contains a specific carve-out for privileged documents, or what the Act refers to as protected items. This means that trustees have the right to withhold privileged documents from the regulator. However, it can sometimes be the case that trustees want to demonstrate to the regulator that they have acted on the basis of legal advice, or they feel that they want to be as transparent as possible. Trustees in those circumstances will need to think about whether to waive privilege over the advice that they have received. The key consideration here is the concept of limited waiver that we mentioned earlier in the context of trustees sharing the advice they have received with employers. Where trustees decide not to rely on privilege to withhold a document from the regulator, it is important to take steps to try to ensure, as far as possible, that privilege is only lost as against the regulator, and that the advice otherwise retains its privileged status. Trustees should make clear that they are providing the document specifically for the purpose of the discussion with the regulator, and that they do not intend for privilege to be waived more widely.
We've talked about limited waiver in the context of trustees sharing advice with the employer, but often the employer will want to share advice with the trustee as well. If the trustees received advice from the employer, that might be within the scope of an information request by the regulator. And like with other documents, there may be circumstances where the trustees want to provide that advice to the regulator voluntarily. The important point to bear in mind here is that where the employer has provided advice to the trustee in confidence, the employer would usually still have the right to assert privilege in the advice against the rest of the world, including the regulator. So if the regulator asks the trustee to provide certain documents, and legal advice shared by the employer is within the scope of the request, what should the trustees do? The first thing for the trustees to consider is the terms on which the employer shared that advice. The sharing of material by the employer is often subject to a non-disclosure agreement, which may or may not permit voluntary disclosures to the regulator. You should bear in mind many non-disclosure agreements also permit the trustees to disclose any material that they're required by law to disclose. But that doesn't extend to privileged material, because the whole point of the privilege is that the trustees can't be compelled to disclose the material. If the agreement doesn't allow voluntary disclosure, the practical answer is often to engage with the employer to seek their consent to disclose any material in which the employer has a claim to privilege. And if there's other material which the trustees need the employer's consent to disclose, that can be picked up at the same time. The trustees are really trying to steer a course that ensures that they maintain a positive relationship with the regulator, whilst not putting themselves in breach of the non-disclosure agreement. However, there may be circumstances where there's a genuine disagreement between the employer and the trustee regarding whether a document is protected by privilege at all. We've been looking at a recent case in the financial services sector, which provides some guidance on how this sort of situation might be resolved.
Yes, Tom. There's a recent case, memorably called A and B, where an auditor was required to provide documents to its regulator, and many of those documents belonged to the auditor's client. A dispute arose when the client argued that some of them were privileged, and the auditor disagreed. The parties couldn't agree what to do and applied to the court. The court said that the auditor had a statutory duty to comply with its regulator's request, unless the documents were in fact protected by privilege. The auditor could not decline to provide documents merely on the basis that its client had asserted that they were privileged. The court said that they can apply to the court for a ruling to determine whether or not the documents were in fact privileged. This issue would then be resolved before the court between the auditor and its client, without the regulator being involved in those proceedings. Which makes sense when you consider that the whole debate around whether a particular document was privileged would be pointless if the regulator heard the content of the document by being in court while the issue of privilege was debated. If the court decides the documents are privileged, the auditor would be unable to disclose them without the consent of its client. On the other hand, if the court decided that they were not privileged, the auditor would have to disclose them in accordance with its statutory duties. If any of you would like to see this case discussed in slightly more detail, we have recently published an article which is available from our website and LinkedIn profiles.
So taking this back to the pensions world, it may be that the regulator asked the trustees to disclose a document that the trustees had received from a sponsoring employer, but the employer says that the document is privileged and should not be disclosed. If the trustees do not accept that, then there is a tension between complying with their obligations to the regulator and the employer's claim to privilege. If this cannot be resolved by a constructive dialogue to find a way forward, then the way out of the dilemma is an application to the court to determine whether the document is privileged. Stuart, if it is necessary to go to court, can you tell us, as a litigator, how long you think that would take?
I think you're right, Beth, to say if, because you'd hope that if the claim to privilege really doesn't stand up, then the party asserting privilege wouldn't let this go all the way to court proceedings. But privilege can be a tricky issue, so there will sometimes be cases where there is genuine doubt. The High Court's very good at dealing with matters very quickly, where speed is important. But I think it's reasonable to assume that even with everyone working towards getting the application on as quickly as possible, there will be a delay in the information gathering process pending the court's ruling.
Yes, and it's worth adding to that even if a court process is moving quickly, any court process will inevitably take some time. So if a matter does have to go to court, the trustees might want to make sure that the regulator is kept informed as to the steps that are being taken, obviously without giving the regulator access to the documents in question.
Great, thanks both. Now, for those of you that have listened to my joint podcast before, you will know that I like to finish on a bit more of a light-hearted note. So, Stuart and Tom, can you tell us what your favourite book is, please?
Well, during the lockdown, it's been great to get away, at least in my imagination, even if not in reality. So I've really enjoyed reading A Movable Feast, which is Ernest Hemingway's account of living in Paris as a young writer.
And I'm reading The Rise and Fall of the Dinosaurs by Steve Bursati, who's a paleontologist up in Edinburgh. It's very good.
Great, thank you both. So if any of you have some downtime in the summer months, then you've got some great recommendations of what to read there. Thank you very much for listening. Please feel free to email me with any comments or questions on this episode to bbrown@mayorbrown.com. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.